Hello, everyone. Thank you for joining us on Facebook or YouTube. We're so happy to have you here joining our community conversations. My name is Kat Periel. I am the Campaign for Justice organizer with the ACLU of Florida, and we are thrilled to have State Attorney Harold Pryor join us today to speak with us about criminal justice reform. And so before we get started, I will do a quick introduction bio for both State Attorney Pryor as well as Melba Pearson. So first, State Attorney Pryor serves for the 17th Judicial Circuit representing Broward County and oversees an office of over 200 prosecutors. State Attorney Pryor had previously served as an assistant state attorney prosecuting serious felony offenses and has also worked in private practice at several prominent law firms for a telecommunications company. He is a past president of the historic T.J. Reddick Bar Association, Broward County's Black Bar Association, and he also campaigned to persuade the Broward County Commission to rename the North Wing of the courthouse in honor of the late Judge T.J. Reddick Jr., the first Black attorney to open an office and practice in Broward County, and the county's first Black judge. He is an active member of the Broward County Bar Association, a volunteer with Broward County School District's My Future Is Now program, as well as a member of the Urban League of Broward County's Young Professionals Network. As the county's chief law enforcement official, he is committed to making sensible reforms to our criminal justice system. So once again, we're so happy to have him here with us this evening. And facilitating our discussion tonight is Melba Pearson, the Policy Director for Florida International's University of the Administration of Justice. I did go to FIU, so I will celebrate that. And she's also the former Deputy Director of the ACLU of Florida. Melba has also served as a prosecutor in Miami-Dade County for several years. And also toward the end of the hour, we're going to be taking questions from the public. So please make sure to put your questions in the chat as we have this conversation. And now I will happily turn it over to Melba to facilitate our discussion.
Great. Thank you so much, Kat, and good evening, everyone. Thank you so much for tuning in for this community discussion. Very excited to have this chat with somebody that I know very well. We basically came up together in the ranks of prosecution, so very excited to talk through some of these concepts that we're going to be covering today. So first off, we're all here because we have concerns about our criminal justice system. Number one, is it being just? And are people being treated equally throughout the system? Unfortunately, we know that the answer to that is no. As many of you may be familiar with the ACLU of Florida's report with regards to racial differences within the criminal justice system, it was more targeted towards Miami, but the ACLU has been on the front line of really looking at the data with regards to how people are being treated unequally. And of course, making sure to raise awareness so that as educated voters, as educated community members, we can effectively advocate for change. So getting started, the first thing we're going to talk about this evening is bail. The concept of bail can be a little confusing to folks. So, I'm going to, Harold, if I may call you by your first name because of the fact that we know each other. It's not a disrespect of the title. But Harold, if you could explain for folks what bail is and how do you make decisions around bail in Broward County? What are some of the policies around that?
Well, simply put, thank you, Melba, so much. And thank you to the ACLU for hosting this. I think it's important that we have forums like this to engage with the community and to talk about the serious issues that confront our communities and that we all care about, and issues that I care about dearly. Look, cash bail is a system, to put it simply, a system of the haves and the have-nots. If you have money, you can get out while you're waiting trial. If you don't have it, you're more than likely going to stay in. And that is inherently unfair. So, for example, if someone commits any one of the enumerated offenses that are in the Florida statute, while you're waiting your day in court, your trial date, or the resolution of your case, you could be held on bail, and you'd have to pay cash or a percentage of whatever that bail may be, according to a bond schedule in whatever jurisdiction. We have a bond schedule in Broward County. So if it's for a third degree offense, the bond could be anywhere in the range from $100 to $500, right? And so pretty much if you can come up with the money or a certain percentage of that money to bond out, then you can get out, and wait your day in court. If not, you have the potential to stay in there until the end of your case, until your case is dissolved, until you go to trial or you decide to plea out the case. Traditionally, prosecutors, not only in South Florida and Broward County, but throughout the country, use this as leverage. Use this as leverage to get people to accept plea offers. People would plea out to cases that they probably otherwise wouldn't plea out to because they maintained their innocence or because they didn't do it, or for whatever reason. And so that system, I think we all are realizing as a country, as a nation, as a community, is somewhat inherently unfair. And we need to change that. And that's why I'm here to have that discussion. And we're taking steps to do that.
So yeah, if Harold, if you could expand a little bit more on what steps your administration is taking to make sure that people aren't being held just because of poverty, and that the focus is on whether or not the person poses a danger to the community versus how much money is in their wallet or pocketbook.
Yeah, well, Melba, my office has adopted a new policy specifying or addressing cash bail reforms in order to reach and maintain a better balance in the system. And so what we're doing is we're going through the bond schedule right now, and we think the first step for Broward, than doing the broad scale, just sweeping, eradicating cash bail, we're focusing right now on the low level offenses and possession or drug cases, and non-dangerous offenses where there are none victim involved. And so right now we've been working with the public defender's office and other stakeholders, the sheriff's department, and actually looking at all of the enumerated offenses on that bond schedule to see what offenses we're willing to say, Your Honor, this person should be released on their own recognizance. There should be no monetary conditions placed upon those offenses while they await trial, and they should be allowed to be home while they wait their day in court, or if they do decide to plea out a case. I think that's a significant step in this jurisdiction, but it's a significant step anywhere in the state because not many people are taking this bold step. And I think it's our first bold step in totally eradicating cash bail. In order for systemic change to happen in anything that you do in life and anything in the criminal justice realm, it's important that you get all the stakeholders involved. And so I think it's a 2 or 3 step process. It's first looking at the policies, seeing how it fits our circuit, educating our judiciary, right? Also educating our law enforcement agencies, and also educating our attorneys, our prosecutors in the office who have been conditioned to think a different way. And I often say this with cash bail, it's not only the prosecutor. At the end of the day, I can stand up in court and tell the judge that we want we don't want any monetary conditions placed on a particular person's ability to be in jail or released. And a judge can ignore that. A judge can make their determination. There's other factors that play in that. We play a major role in that in making a recommendation. But as we know, judges still have their discretion. And so a lot of this comes with educating everyone, all the stakeholders that are involved in the criminal justice system.
Great. Thank you for that, Harold. So you had mentioned a little bit about low-level offenses, and I want to turn to and talk a little bit more about that. Many of us have heard some horrible stories about people who end up being arrested and incarcerated for something that's a low-level, non-violent offense, and now they're in a situation where they end up losing their job. There's a lot of collateral consequences, and it also wastes taxpayer dollars, right? Because anytime someone's incarcerated, that's tax dollars that's being used to be able to house them. You'd spoken about this on the campaign trail. Do you have a policy with regards to releasing people on their own recognizance? So basically releasing them without monetary conditions for low-level offenses? And what is your stance with regards to technical violations of probation? So again, giving a little clarity to the audience, somebody is on probation for an offense, something along the lines of, they failed to report, they didn't call their probation officer on time, that is theoretically a violation of probation and could subject someone to being arrested. So what is your office doing around release of on your own recognizance for low-level offenses as well as technical violations of probation?
Well, we right now have a policy right now where we look at those low level offenses, and traditionally we are recommending that those people be released on their own recognizance for those low level offenses, most misdemeanors, some third degrees. Most third degrees are possession of cannabis cases that come across our desks, grand thefts, and other offenses, even some traffic driving offenses. And so those are the offenses that we're looking at. Mainly, those are the offenses that people are being caught up with, people that are being stuck in the jail and they can't get out on. But I will have to say this, and I would be remiss if I didn't mention this point. I'm extremely proud of our circuit and how we've been doing things. I believe the last time I look at the numbers, when you look at the jail population, which could be between 2,800 to 3,000 any given time, a small percentage, I think less than 3%, just to be safe, I'll say less than 5% of the people that are in custody are in there for low level offenses. I think we do a good job, and we've done a good job as an office in educating our attorneys. And also, the judges have done a better job as well, working with the public defender's office and also the defense bar to address those individuals that are being held for low level offenses and to see how we can get them out, so they're not clogging up the jail system. And you tend to want the more serious offenders in there rather than low level offenders. And so I think that's a great thing. The one positive that we can take from a global pandemic, it forced all the stakeholders, the sheriff's department that runs the jail, the judiciary, my office, public defender, and other members of the defense bar to actually sit at the table and say, okay, how do we lessen this jail population? And so we had to sit down, go through cases, and identify those low level offenses and ensure that we weren't holding people. And so it forced us to come to the table and do that. And so I'm happy that we've made that step. Now, next to the next point regarding the technical violations, those are issues. But I will say in our circuit, we've also done a better job. And also it comes with a training, and that's going to be an ongoing, continuous thing where we train our attorneys to really look at these issues, to look at these technical violations that might be, like you said, failing to report, a dirty urine test, not a new law violation, something where they just didn't comply with the condition of probation. We're trying to train our attorneys to actually read between the lines, not go along with the rubber stamp that comes along with Department of Corrections when they look at these, and actually kind of look at these with some level of compassion and giving people second chances. And so really that's just a training issue, which we've been doing. We've been alerting our attorneys to these issues, to be more sensitive to these issues, to ensure that we're not holding people in jail for technical violations. But once again, I'm also proud to say that we as a circuit, for the number of technical violations, people that are being held in jail for a significant amount of time for technical violations, is relatively low. I'd venture to say, once again, it's below 5%. And so really the main issue, what we're dealing with, is those people that commit the substantive violations, new law violations. You're on probation for another case that you committed, or a crime you may have committed in 2016. You're on probation for 6 or 7 years. And while you're on probation, you commit another offense. And so normally those people are held on no bond. There's a no bond hold on those individuals until they resolve those cases. And oftentimes you run the danger of spending time in prison for violate, or some time in jail for violating that probation. And so it's important that the defense attorneys get their discovery, that they do their due diligence and doing depositions and following through to actually litigate those issues, because those are actual trials essentially. And so that's why sometimes people are held up. And then also it kind of forces people to actually resolve a case that they might not otherwise want to. And so we try to be sensitive to those situations. We try to train our attorneys to pay attention to those issues, be attentive, and be fair, and be reasonable. And we've given more discretion to our attorneys so they can make the right call in the moment. And so you'll see a change in that as we move along. Once again, I have to remind people, we're only 9 months in. And some of these issues, the issues that have been going on in the criminal justice system, have been going on for hundreds of years. And so we're trying to turn it around. If I could turn it all around in a year, believe me, I'd do it. And you better believe I'm working like hell to do that. But we're only 9 months in, and we're working towards creating this change that we all want and desire.
Yeah, absolutely. Listen, Rome wasn't built in a day, right? So you got to be very intentional, especially when you're trying to dismantle systems that have been in place, basically since slavery. But just to kind of put a finer point on this aspect, why is it so important to you and to your administration to make sure that jails are reserved for the most violent offenders? What does that mean for the community at large, especially the community in Broward County?
Well, that's a great question, Melvin. I think it's the root cause, or rather the root of why I decided to get into this. We really need to redefine exactly what public safety is, what the safer communities mean for us as a community. And so, i- are we a safer community by holding people in custody for exorbitant amount of times for low level offenses, for possession cases? Or are we a safer community if we hold people in there who pose a danger to our children, who pose a danger to our communities? Those are the people that I think jail should be reserved for, or prison should be reserved for. And so it's important for me, as the state attorney, as the chief law enforcement officer of the circuit, to ensure that we kind of steer the discussion, but also guide the policy on what public safety actually is. And so it's important for me that we don't overpopulate our detention centers, that we don't overpopulate our prisons. I think one, for a resources issue and economic stance of closely guarding and being good stewards of our resources and taxpayer dollars. And there's no economic or taxpayer benefit for housing or having these prisons or jails at max capacity. We're just spending more money, and I don't think that benefits the community as a whole. And so I think for a more practical stance, I think it makes sense, but also in a practical sense of safety and who, in fact, we are detaining. I think that's an issue, and we really need to focus on those violent offenders, those people that prey on members of our LGBT communities, members of our Jewish community, our African American brothers and sisters, our Hispanic brothers and sisters, various members of the immigrant communities that come here to South Florida that are preyed on by people, by predators. Those are people we need to focus on. We don't need to focus on people that may have mental health issues or drug addiction issues. We need to put them in problem solving and therapeutic courts, to actually get them the help that they need, and identify the services that can help these people with the issues that they need help with.
Yeah. So, staying on that same topic of jails, as we all know, we're still in the grips of a global pandemic. And COVID did present us with a lot of challenges, but it also presented us some opportunities as well, especially in terms of reforms that make sense and also keep our community safe. So, what changes has your office made with regards to what who ends up in custody in light of the fact that we have this pandemic? And of course, making sure that, again, knowing in the jail situation, it's very hard to socially distance and all of that. So how are you going about this to make sure that people are staying safe and also keeping in mind this virus and how it can,
Yeah.
really spread and cause problems for all of us?
I know we're dealing with the ACLU, and I don't like to impose my personal beliefs on anyone, and I'm not imposing my personal beliefs on anyone. But I am a spiritual person, and in my beliefs, traditionally, when you look at my religion and beliefs, and when I read the Bible, whenever there was changes or systemic changes or a paradigm shift, there was something that was often catastrophic that would happen that would force you to do something, force you to move, compel you to move. I can point to countless passages in the Bible that I would read where there was some catastrophic event, but at the end of that catastrophic event, there's a paradigm shift. And I equate that to the global pandemic that we're experiencing right now. We had this global pandemic, and it actually forced us as an office, I can only speak for my office, to do things that we probably normally would not have done, even the criminal justice system. Zoom hearings. Melba, could you imagine even 5 years ago us talking about doing hearings via Zoom, meeting with victims via Zoom, having defendants, people who are accused of crimes, actually appearing in court via Zoom and actually saving resources? They don't have to take public transportation because that's not reliable in Florida. And them actually coming to court on time and not having to lose their job or obligations, or not leaving their children with people they necessarily didn't want to leave them with, or leaving them home by themselves. We saw a shift there. But also policy wise, we saw our office make offers on cases, reasonable offers, great offers that we normally wouldn't give under normal circumstances. It forced us to step outside of our comfort zone and say, hey, you know what? Maybe prison or jail time isn't the best alternative here, right? Maybe there are other things or other offers that we can make to really address the root causes of these issues. And so it forced many of our prosecutors, many of my seasoned prosecutors that have been here for 20, 30 years to think outside the box and look at the criminal justice system in a different light, in a different respect. And I think what we've done as an office is, one, we've given our prosecutors more discretion. That was the problem. Our prosecutors here didn't have discretion, and as a result, there's a backlog of cases. We have cases that are still pending from 2017 to 2018 that aren't being resolved because of a dated policy of, hey, you can't plea out a case until you get supervisor approval, or you can't break down a case or change the charge of a case or even drop a case, even if it's warranted, right? The facts aren't there. The evidence isn't there. You still need supervisor approval. And oftentimes, you'd have cases linger on and on and on, and you have attrition and people leaving the office and they get promoted to other units, and you just have these cases sitting here. And that was a problem. So we've given more discretion to our prosecutors to do the right thing, to make the right decision. We trust our prosecutors to do that. But also, we've increased our training of our prosecutors to really look at some of these issues and really pay attention to these nuances and reading between the lines. And then also another thing that we've done in the global pandemic, we've actually asked the sheriff's department and the judiciary to share a list of the people that are being detained. And so every day, almost every day, I receive a list from the judge, Judge Siegel, who's the administrative judge for the criminal section. He sends it to myself, the public defender, and we get that list from the jail, and they give us daily updates of those inmates, those people who are being detained, waiting trial in a local jail, who may be COVID positive, right? And so we're going through those lists and we're seeing, how can we resolve these cases? How can we come to resolution so we can get them out, and so we're not infecting the jail population? But also, we're going through lists of people who aren't COVID positive. We're going through lists to see, how can we lower the jail number there, the jail count there? What are some cases that are just lingering, and how can we plead these cases out? And so the pandemic has really forced us to think outside the box. It's forced us actually to be more proactive, because before the pandemic, no state attorney's office was contacting the jail and saying, hey, give me a list of all the people that are being detained and how can we plead these cases out. We often sat back on our laurels and we said, well, it's either go to trial, you accept my unreasonable offer of prison. If not, we go to trial. Or if not, you take the offer. Now we're being proactive and actually trying to resolve these cases and trying to be reasonable. And so that is the change, I think, in the pandemic for our office, is that our prosecutors are being more proactive. We're identifying cases where we can be reasonable, and so we can get people out and they can move on with their lives. And I'm really proud of the work that our prosecutors have done, because we've asked them to do a lot, to step outside of their comfort zone of actually, going to court, doing discovery, meeting with witnesses, meeting with victims, going to depositions, arguing motions, and going to trial. We've actually added 2 or 3 more components of that. And I think ultimately we're going to come out better as a circuit because of the extra work that our prosecutors are doing.
And with regards to now the Delta variant, right? Because we thought, we were like, okay, we got coronavirus, all right, that's the thing. And now we've discovered, Delta. Are you changing anything in your office to adapt for this new variant? So have you implemented any new policies as a result of the variant, or still just proceeding with what you did with the initial outbreak from the pandemic?
Yeah, we're treating the same. Really just being vigilant. I'll speak from a practical sense of running an office. We have signs up. We have our attorneys not congregating in common areas. We have attorneys asking them to stay in their offices when they are working. Practice social distancing, wear their mask. But also in the respect of pleading out cases and really doing what we need to do. We have a unique place in the judicial system. We have to be here. Everyone else, I joke all the time, everyone else can go home and do their thing, but the wheels of justice, it doesn't stop. And these people are depending on us. Victims are dependent on us because sometimes we're the last line of defense when they've been victimized. Um, Witnesses of cases, we have to keep in contact with them. And also those people that are being held in custody. At the end of the day, whether they did it or not, they want a finality. They want an end to their case. And so if we're just sitting at home and we're not doing our jobs and we're not holding it up our end of the bargain, we have a clogged up judicial system. There's no finality. There's no end to these cases. And we need to be doing our job. And we're doing our job. And we're being vigilant of COVID-19. And like I said, like the extra steps that I said earlier that we're taking, we're continuously taking those steps. And we're highly vigilant now. I think we're more vigilant than we've ever been before with these cases because we're looking at it from a global perspective. And I think we all benefit from that. I truly do believe that. I think our defendants, people who are accused of crimes, they benefit from that. I think the victims of crimes benefit from that. And I think everyone in there, in the entirety, in the whole judicial system and criminal justice system benefit from us being hyper vigilant during this time.
Yeah, yeah. So next topic is that of pregnant people in the system, right?
Yeah.
So I know that you're a new father times two. So I know that this is probably an issue that hits pretty close to home for you. But, many of us heard about the horrors of what happened with Tammy Jackson in the Broward County jail and how she was forced to give birth by herself. We know that in 2020, legislation passed in Tallahassee, the Tammy Jackson Act, to prevent this from happening again. But now we discovered the same thing happened to a lady in the Alachua County jail, where unfortunately her newborn passed away after she was forced to give birth by herself in her cell. So what is your administration doing in this regard to ensure that pregnant people have their dignity and are not incarcerated while they're, when they're about to give birth and all of that? What are you doing to preserve the dignity of new parents in this way?
Well, I think one thing I can do is be vocal. We don't control that aspect of it. We control the charges that are being brought against the individual, whether or not they're being held for a particular crime, and working with the judiciary and making a recommendation. But one thing that I can do is be vocal and be vigilant and incorporate some of the practices that we've done. We're constantly asking for lists of those individuals, those women who may be with child pregnant during the time. And we try to monitor those cases. We instruct our prosecutors to monitor those situations. We review those cases to see, okay, why are they in custody? How serious is this? Can we get them out? Can we release them on our cognizance? And if you have to, can we put them on an anchor monitor if you really think that they're a danger? If you do, right? But we are reviewing those cases. We keep on top of it. We're constantly asking for lists from the jail to review to make sure we're on top of it so we avoid that situation. I can't speak for the sheriff, but I do know that the sheriff has been hyper vigilant ever since that incident. And I know he actually went to the extreme of firing the major who was over that detention center. And they're changing the policies there where they're hyper vigilant of that as well. So coupled with the sheriff's department doing their job, monitoring those situations and keeping us aware and us looking at those cases and staying on top of them to see if we can resolve them or avoid detention entirely. That's always a goal of my office.
Staying in that same vein with regards to primary caregivers, right? So as we're thinking about parents who have a young child at home, maybe a single parent and has no one to leave their child with, if they're involved in the system, or you're caring for elderly relatives or parents or something along those lines. Sometimes people who are in that situation and find themselves involved in the criminal justice system may feel the need to take a plea because they need to get back home to their loved one that needs care. So what is your administration doing around that issue to make sure that caregivers have alternatives to incarceration so that people can get the care that they need, but still that accountability is happening?
Yeah, it goes back to my point. We need to restore, or we need to inject. Probably not restore because it probably was never there. We need to inject compassion in the criminal justice system and what we do on a day to day. A lot of people that commit these acts, very few people, a lot of the people that we come across in the criminal justice system, sometimes they're one-time acts. or just mistakes. So sometimes we have to look at it and inject compassion into what we do, and be able to read between the lines. And I say that to my prosecutors all the time. Don't be afraid to read between the lines. Don't be afraid to question a probable cause affidavit. Don't be afraid to scrutinize some of the cases that come across your case. Don't be afraid to say no and speak up and speak out. We foster that environment in our office, and sometimes to my detriment. I'm joking, but it's good. And but I love it because it creates an open space of ideas. And so once again, it goes to training. It goes to giving our attorneys discretion. And so we're training our attorneys to really understand nuance, to be open to understanding different nuances in the individual's lives. What may motivate this person to commit a grand theft? What may motivate this person to go into a Walgreens and to take two things of formula and diapers, right? If you just look at that alone, you're probably thinking, okay, maybe they're trying to make sure that their 4-month-old has enough diapers and formula and they can't afford it at that time, right? And so what are we doing? Are we gonna throw the book at this individual for doing that, or are we going to try to create a teachable moment and maybe try to help them find resources so they don't feel that they need to do that? And so that's where diversion programs come in. When you have an office that has diversion programs as the norm, the rule, and not the exception, you can avoid these situations for people who commit mistakes like these or even crimes like these, who may be the sole caregivers. And you can look at that nuance and use that as a justification for giving someone a second chance. And that's what diversion programs do. Diversion programs offer those opportunities for those individuals so they can remain with their families. And we're not approaching it with a hard hand approach.
Yeah, yeah. So pivoting now to admissions of guilt. So question number one, does your office require admissions of guilt in the field? So basically at the time of arrest in order to receive a civil citation or some other form of pre-arrest diversion, right?
Right.
So in order to make sure that you don't get arrested, are you requiring people to admit to their guilt?
Well, no, great question. So, with the civil citations, when an officer comes in contact with an individual, an adult or juvenile, we don't control that. That's purely a discretionary function of law enforcement agencies when they issue civil citations. Once an individual is placed before our office, once they make it to court, or if that case is in fact filed, then they could be, if eligible for entry into one of our many diversion programs. One of the changes that I made that I announced 2 months ago, we are no longer requiring admissions of guilt for entry into our diversion programs. That was always a requirement for our office. If you were going to enter in one of our many diversion programs, before you entered in, you would have to write out an admission of guilt. I did X crime. And then we'd get that, we'd attach it to the file, you'd sign up, you waive speedy trial, and then you go into the diversion program. We've removed that requirement. So it's no longer a requirement for you to sign an admission of guilt to enter into our diversion programs.
So I don't know if everybody understands how huge that is. I mean, that is a massive, massive, massive reform. And thank you for doing that. Can you break down a little bit more why this is so important and the consequences that it could have for people?
Yeah. Well, the consequences could be grave. Oftentimes some prosecutor offices use that as pretty much leverage. They hold it over their heads. Someone that's entering into a diversion program, someone might not be able to complete a diversion program. And so what happens is you're kicked out of the diversion program, and prosecutors around the state, and my office used to back in the day, they could use that against you should you go to trial, right? But as we know, diversion programs, people can't complete diversion programs for many reasons. It may be cost prohibitive, right? You probably can't afford to do it anymore. It's time prohibitive. I mean, it's a huge commitment. 3, 6 months, sometimes a year to go through some of these programs. And it takes a lot of time to actually go to some of these programs to do some of the community service hours. And some people can't do it for one reason or another. Most people, I would venture to say, they can't do it because of job obligations, right? They don't have the time to do that. And so I didn't want to punish anybody for that in that sense, to hold that over their head. It's still a privilege to take part in a diversion program, but I'm very sympathetic to the normal constraints of life, the challenges of life that people may experience for one reason or another as to why they can't complete a diversion program. And so I think that was necessary to have admission of guilt as a requirement for our office, for people to enter into a diversion program through our office.
Awesome, awesome, awesome. Great work on that one. So now turning to marijuana. As we all know, many parts of the country have legalized it, but Florida being Florida, we haven't gotten there yet. So I know that you had spoken about on the campaign trail doing some sort of minimum threshold before your office would prosecute, and I believe that was in the amount of 20 grams or so. So what is your current policy with regard to cannabis charges, and what policies do you have in the works with regards to that? Because unfortunately, we know that Black and white people, Black, brown, and white people all use cannabis at the same rates, but Black and brown people are disproportionately arrested and jailed for using the same plant that is legal in half the country. So what are your policies surrounding that?
No, it was a great question. It was one of the first policies that we made a change on, and it was a campaign promise that we followed through. We are no longer prosecuting standalone possession of cannabis cases, 20 grams or less, or standalone possession of drug paraphernalia cases. And those are all misdemeanor amounts. That's significant because it's the first time it's ever been done in Broward County. And oftentimes we attributed that to a crime of over policing. Our communities, Black and brown communities, are over policed at a disproportionate rate. And oftentimes, the offenses that people are put in for, or cases that are brought to our attention, are possession of cannabis and possession of drug paraphernalia cases. But also, what we saw too, it takes an exorbitant amount of money and resources to actually try these cases and to maintain these cases, right? If you come in contact with someone with cannabis, you have to field test it to see if it initially is cannabis, right? That costs money. Then once you transport it to the crime lab, if in fact this case goes to trial or even before, you have to weigh it, you have to test it. That costs a lot of money for the Broward County Sheriff's Office, and then ultimately for us, if in fact we do bring one of those cases to trial. And so it was a strain on our resources, not only state attorney's office, but our various law enforcement agencies around the county. But also there was a growing trend. If you look at the growing trend throughout the state, many people, I think it's in the high 70%, people are more receptive, and they're more accepting of cannabis usage for medicinal purposes and even recreational use. And so when you look at the interest of the people, the public policy of the state of Florida and also Broward County, it was an easy decision. But on top of that, it was a practical numbers thing. I'm a numbers guy. When you look at the numbers from 2015 on to 2019, the thousands, the tens and thousands of possession of cannabis cases that was presented to my office, in 2015, I think we only filed 10% of those. Then it went down. And then ultimately in 2019, we were only filing 5% of the cases that were presented to our office, which were in the tens of thousands. So you saw a growing trend even before me taking office, even with my predecessor, and even around the state. I'd venture to say around the state, you saw a trend of the decrease in filings for possession of cannabis cases. So it was an easy decision for us, both practically for public policy reasons, but also for resources, to ensure that we're guarding our resources and we're good stewards of our resources, to actually focus those resources on the serious and violent crimes that occur in this county, rather than focus on these low-level drug offenses, these misdemeanor level offenses. And so it was an easy decision for us, and I'm proud of it. It's been great so far. We've gotten a lot of great feedback from members of our law enforcement agencies and the community, and I'm excited to see how far we can take this. And from my understanding, it looks like members of the legislature are looking to present some form of law and legislation to kind of codify pretty much what we've done here in Broward and what they've done in Miami-Dade and I think other jurisdictions. And that's the first step. And all you need is a first step, and then it can grow into something else. And so I'm excited to see where we move along and how we progress in this area of the law.
And what is your stance with regards to drug paraphernalia? Is your office
Yeah.
prosecuting that, and how is
Yeah,
that being
once again,
handled?
standalone drug paraphernalia cases, we're no longer prosecuting those cases if they're standalone. If they obviously accompany a more serious crime, a drug trafficking crime, or a higher level of drugs, we're still going to prosecute those cases. But if they're standalone, if you have an individual that's driving in a car and they commit a driving offense, or they're just being stopped for failing to use their indicator, and then so happen, the officer suspects that there's marijuana, but they can't tie it to this particular individual, but they see a pipe, and they charge this individual with drug paraphernalia. We're more than likely not going to bring that charge because it would be a standalone possession of drug paraphernalia case, and our policy is to no longer prosecute those cases.
Great. Now, pivoting back to diversion, and I know you had touched on that in some of the answers that you gave over the course of the last 45 minutes. But, when you were campaigning, you were talking about deprioritizing charges that are connected to poverty, or addiction. So things like failure to pay fines, or loitering, trespassing, sex work, those types of charges, misdemeanor property crime. What policies have you adopted around those types of issues? And then the second part of that would be diving a little bit more deeply into the diversion program. So, can you first talk us through the policies with regards to charges tied to poverty and addiction?
Yeah, I'll say this. I'll tell you this much. It was easy in that sense, and to make diversion programs a rule and an exception, you need to cast a wider net as to level of offenses or the type of offenses that you allow into your diversion program. And so what we did in our felony diversion program, our PTI program, we've essentially allowed all possession cases. So if you're a first time offender for possession, you have an opportunity to participate in our pretrial intervention program, our diversion program. Before, it was only limited to cannabis, and we would present some cases. We would have allowed some cases of possession of cocaine. Now it extends across the board. And then if a person chooses not to do that, then they have the opportunity to go to drug court if they have a drug issue and they want to acknowledge that they have a drug issue. And so, really, what it was is just us looking at the crimes, the offenses that we think that should have been allowed in, and we decided to cast a wider net to allow more offenses in, to allow more people in. I'm proud to say that we don't look at 2020 because 2020 was an anomaly. It was something that we don't count, but we looked at the numbers of 2019. So from January 2019 to September 2019, when you compare our diversion entry rates to now, January 1, 2021, and September of 2021, we've increased our diversion entries to 40% so far. That's significant because we've casted a wider net. We've allowed more offenses. We've actually been more receptive to, okay, if you committed an offense a second time and we look at the facts, we may be willing to let that in. It's not always the case, but sometimes we'll look at it on a case by case basis. We've essentially said, rather than create these hard, stringent requirements, which we do have criteria, we do allow prosecutors who are over our PTI program to look at it on a case by cases, to look at the nuance, as I discussed earlier, and each particular case and see if that person is warranted into getting into our diversion programs. So we've been a lot more lenient in allowing people in, giving people second, sometimes third chances. And that's what you do. You just really cast a wider net and you give people opportunities to really turn it around. And so just allow them expand the list of enumerated offenses and be willing to grant people a second chance when you look at their particular case and you're able to look at the different nuances in any given situation.
And then can you walk us through the diversion programs that you have available in Broward County currently, and also what you have, in the works, if we can get a coming attraction or a sneak peek?
Yeah, so in misdemeanor, we have our misdemeanor diversion program, which is run by it's in partnership with the Broward Sheriff's Office. And so there's a list of enumerated misdemeanor offenses that we'll allow in. If it's a first time offense, we'll allow you to get in. And so it covers a lot of the misdemeanor offenses. Then you have our PTI program, which is in the felony level. felony level offenses. We've expanded many of those offenses. So if you commit a first time offense, sometimes second will allow seconds in. If you commit a first time offense and if you're eligible, we'll let you in. You do the program, and once you complete the program, we will drop your case. We also have a domestic violence diversion program that I'm extremely proud of. The reason why I'm proud of this is because before we rolled our domestic violence diversion program, we actually reached out to women's in distress. We reached out to many of the providers of those victims of domestic violence, and we got them to sign on and actually critique and actually redline our diversion program. We also are rolling out our mental health diversion program, which I'm extremely proud of, because far too often our mental health courts and our mental health diversions, they were adversarial in nature. We couldn't come in an agreement. And so we were able to get the public defender's office on board. We were able to get Broward Behavioral Health, various service providers for mental health services in Broward County, the Sheriff's Department, the judiciary to come to the table and recreated a collaborative mental health diversion program. And we actually expanded, we cast a wider net of offenses that we would normally allow in our diversion program. So many people that are struggling with mental health issues, they're going to have a chance to actually be connected with services that can help and rehabilitate them rather than us criminalize them. We're also planning to roll out, I'm proud to announce here that we will be rolling out we will be rolling out a human trafficking diversion program for our younger children that are caught up in the life. And we'll be rolling that out relatively soon. We're in the final stages of that. I'm excited with the children, many of the boys and girls that we're going to be able to affect their lives positively rather than criminalize them, but actually bring them in the fold and actually, once again, nuance, reading between the lines, and actually getting them the help that they need by putting them through the human trafficking diversion program. And then also, we are creating a DUI diversion program. We're in the middle stages of that. We're actually doing reviews. We're going to reach out to stakeholders, and I plan to roll that out relatively soon. If it's not rolled out before the end of the year, we could be rolling it out in January. But also my major thing, and also juveniles. We have a lot of juvenile programs, juvenile diversion programs. We break them up in tiers 1, 2, and 3, and we address really whatever the root cause of that child's issue that causes the delinquent behavior. And so if you have a child that has a particular need, we actually partner with the Children's Services Council of Broward County, and we connect them with the various providers in Broward County that can help juveniles in whatever their particular need may be based on the tier. We are constantly admitting children in our diversion programs, sometimes for third and fourth offenses. We're extremely lenient with our children because we truly believe that they need sometimes second and third chances. And on top of that, we have a civil citation program that we signed with the clerk's office, public defender's office, and the various law enforcement entities. We're going to get all law enforcement entities to sign off. First time in the history of Broward County, all the law enforcement agencies are going to sign off on our juvenile civil citation program. We're going to do a signing ceremony to increase those numbers. And the beauty about civil citations, you capture these children before they actually get a case number generated. And that's important to me because you can capture these children, get them into the program, get them the help that they need, identify the issues that are causing them to commit these or exhibit these delinquent behaviors while not giving them a criminal record. And so that's important for me. It's important for us that we stress civil citations. But it's an exciting time in Broward County because we truly have a state attorney that believes that diversion programs should be the rule and not the exception.
So turning now to the topic of racial disparities in the system, it's been well documented at this point through not only research, but just lived experiences of what, many of us walk on a day-to-day basis, right? And we see the racial disparities in the system. So what specific policies or steps is your office taking to address racial disparities from the prosecutor's standpoint? And how are you dealing with this issue?
Yeah, no, it's twofold. Same thing. It's training. Really, it's training and creating policies. So, for example, With our office, I think racial and implicit bias training is important, because and not just white. It's not just a white thing too, right? Even Black folk can have racial and implicit biases when they're dealing with cases because of their lived experience, right? Or shared experience. So we want to incorporate that. We're in the process of identifying services that we can offer to our attorneys to do a constant racial and implicit bias training, because that plays a role in the offers. What type of offers am I giving? Am I giving a stiffer offer to this Black man with dreads, right? Right, as opposed to a white individual who may seem clean cut, right? Who comes from a different zip code. You may be giving that offer. You may be giving a stiffer offer because of your own implicit biases and prejudice, right? And so we need to work hard to actually train our attorneys to understand that, but also be able to identify that. And you'll notice a change in some of the offers that we're giving to these individuals. But so also, really, the major issue here, because we have a lot of people that are actually doing their work and doing the work and doing great jobs. It's really just getting them to really understand that, in fact, that we all have our own implicit biases and prejudice, and we need to be aware of that. And the first step to changing the racial sentencing disparities that we've noticed in the criminal justice system is acknowledging it, identifying it, and changing our practices and doing it with policies. And so we've instructed our attorneys to really look at these cases, to be fair, and to really understand what are the root causes as to why the system is the way it is. And so I think that's the first step for us in tracking the data and being able to then correct those behaviors. And we're in the process of doing that, i.e., the prosecutorial performance indicator project, in creating that level of accountability for our office, both externally for the community, but also internally, so we can hold our attorneys accountable.
So I know we only have a few minutes, but I want to make sure that we talk about police accountability, because I know that's definitely an issue that's near and dear to most of us, and is an issue of huge concern. We saw the outpouring as a result of the summer of George Floyd, Breonna Taylor, and so many others. But of course, keeping in mind that's just the tip of the iceberg. There's many more whose names we know and don't know, but we say all their names, we acknowledge them, and we fight on in their memory to honor their memory. So what is your office doing to hold bad law enforcement officers accountable for those who use excessive force and prey on our community? What are you doing with regards to that issue?
Melba, I have to tell, I am extremely proud of my office. I'm extremely proud of our prosecutors. Before I even was able to create a policy, we had so many attorneys who were going through their discoveries, looking at body cams that were coming in, and they would report. They go to our public corruption unit. That normally we have a public corruption unit. Our public corruption unit, one of their functions, many functions, is to investigate and potentially prosecute law enforcement misconduct. And one thing I was really surprised with when I took office in January, we would receive, our public corruption unit will receive countless emails, countless referrals of, hey, I'm a prosecutor in such and such division. I was working on discovery. I reviewed this body cam. This is what I saw. It didn't seem legit. We need to open up an investigation. And so that's the beauty of our office. That's the beauty of really doing it for the right reasons. Trying to seek the truth, trying to get it right. And so that's our motto in our office. The motto in our office is, it's not about wins or losses. It's about getting it right, seeking the truth. And so we've instructed our attorneys, and we're training our attorneys continuously to review these cases, review their body cams, the body cams that are submitted, scrutinize, over scrutinize the probable cause affidavits if you have questions, and report to our public corruptions unit. And our public corruption unit then opens up investigations for police misconduct on that end. And so I'm extremely proud of the work that our public corruptions unit does. They're constantly looking into issues that are brought to their attention. We've told them, public, if you see something, say something to us. You don't have to go to a law enforcement agency. You can come to our office. We'll open up an investigation. And so it really is just a communication thing, just letting the community know that we're also an arm that can open up investigations and to look into these matters. And I'm extremely proud of the policy that we have where we instruct our attorneys when you're reviewing your discovery, when you're looking at probable cause affidavits, when you're looking at these body cams and you see something, say something. We'll open up an investigation and we look into it. And so that's really our policy. Our policy is to really do that and to really hold them accountable. We, for years, Melvin, you know this, Melvin, we have been the only circuit that have been willing to bring charges against law enforcement officers for years. In fact, we get calls from state attorney's offices around the state and DA prosecutor offices around the country because of our record of trying police officers. We're not afraid to do it. If there's misconduct, if there's criminal activity, we will prosecute those cases. And I'm proud of the work that our public corruption unit does in that respect. But also, we've changed the practice. We're no longer submitting police involved deaths or shootings when a civilian is killed. We're no longer submitting every case to the grand jury. We have a hybrid system. Some cases we make the review, and in other cases, we will send to the grand jury. But more times than not, we are going to make the determination, and it would be open to public records requests once we've completed our investigation and once it's been done. And that's significant because we all know that grand jury records are sealed and no one can know what's going on in there because everyone involved in the grand jury process is sworn to secrecy. And so that's a significant step. We went from a circuit where we always sent police involved shootings involving civilians to a grand jury to now we have a hybrid system where we will submit, we're going to submit a small amount of those cases to grand juries just based on the complexity of the situation. But oftentimes, some of these situations, we can make a clear determination. There's no need for a grand jury. We can make that determination as an office and be subject to the scrutiny and criticisms of the law enforcement community in the event that we decide to bring charges against a law enforcement officer and the community as a whole, ACLU, members of our Broward County community. The moment we decide not to bring charges against a law enforcement agency, we're willing to be held accountable and be open to that scrutiny and answer any questions that anybody from the community may have.
And so with our final few minutes, final words, Harold, to the people of Broward County, to the folks around the state that are viewing this today. Final thoughts with regards to what you're working on, what comes next, or anything that you want people to know before I turn it back over to Kat.
Well, this is extremely important. Thank you to the ACLU for doing this. I think forums like these are important so everyone can know what we're doing and I can keep people abreast to how we're progressing along. Bear with me. We're working hard every day. I have the community in mind. Every day I have really creating a system of justice that's fair and equitable for all people, that we're initiating criminal justice reform reasonably and prudently while not compromising the safety of our communities. And that's on my mind every day. And we're working hard. Although we've only been in office for 9 months, I'm extremely proud of the work that we've done, the progress that we made. But all these changes won't be made overnight. It's going to take some time, but I want everyone to know that we're working hard as a team to do that because we've been crying out for these changes for so long, and it's about time that we do something about it. And every day we're working hard towards making those changes. And thank you for your support. And we're open to the criticisms. We're open to getting feedback from the community. So thank you.
Great. Thank you, Harold. I'm going to pivot to Kat for Q&A.
Hi, thank you. One, that was a great conversation, and thank you so much for answering all those questions. We had quite a few questions come in through YouTube as well as Facebook. We're going to answer as many as we can, as time is limited. And so these questions are open to both Melba as well as a state attorney. And so if you guys feel that you can answer, then you can do so. So our first question that came in was in regards to your pledge to increase the diversity of your staff. And so if you can discuss specific steps you're taking to ensure that prosecutors, including those in supervisory positions, are racially diverse.
Yeah, no, that's a great question. That's always been a focus of mine. How do you do that? You recruit. You go to the various law schools and recruit. I've reached out to St. Thomas University. St. Thomas University has a great statistic. Overwhelming majority of their law school classes or people that attend that law school are first generation law students, and many of them are minorities, Hispanic and African American. So we have to be proactive in actually reaching out to these law schools with diverse backgrounds and students and try to bring them in the fold. I'm proud to say that my office, 76%, 73%, 76% of my office are women, made up of women. And I think nearly 73% of the attorneys in my office are women. And we have a leadership. My chief assistant state attorney is a Black woman. My deputy chief assistant state attorney is a Black woman. We have a diverse office, various Hispanic members of the Hispanic community. We have members of the LGBTQ plus community that work in our office. I'm proud of our diversity, but it can be better and it will be better. Our Black attorneys in our office, I think we're higher than the number of the Florida bar. We're about at 10%, but it needs to be higher. Actually, we're at 13%. It needs to be higher. Hispanic attorneys in our office, we're near about 16, 17%. So we're actively recruiting in that area, and I'm very proud of that and the steps that we're taking now to ensure that we have a diverse office.
Thank you. Sorry, my dog is barking in the background, so I apologize, everyone.
My
Um,
son, my son is screaming in the background, so we're even.
the second question that we had come in is in regards to juveniles in the adult criminal legal system. And so, what specific steps or policies will you implement in order to make sure that prosecutors don't directly file minors into the adult system?
Yeah, and you know, I say this time and time again. My fundamental goal is not to direct file children, to charge children as adults. But the harsh reality is sometimes that will happen. However, concern, my focus is how do we avoid that for future situations? And so, what do we do as an office to avoid that? And so, what we try to do is create more diversion programs. We have civil citations. We're trying to create programs to identify those children that we think could escalate to something serious, right? And so we try to bring those children in the fold, get them the services that they need. So I'm not making that determination down the line. It's a tough decision when you have children that are younger than 18, right? And they commit a heinous crime, a murder, right? And then you have the victims of the family that you have to meet with and deal with on a particular sense, and you have to balance, how do I hold this child accountable, but also understanding that they were young, their age, they were young at the time that they committed or alleged to have committed the offense. And so those are tough decisions that prosecutors have to make around the country. And so my focus really is, how do we address the root causes so we avoid that child who could become that danger 2, 3 years down the road? How do we identify that child when they commit their first juvenile offense that may not be serious? And how do we offer services to bring them in the fold, so we're not making direct file decisions?
Thank you. And we are short on time, so we're going to take one last question. And that is, if someone in your community thinks that they have been unlawfully arrested, what should they do?
So if you believe that you've been unlawfully arrested, there's so many avenues, and I know Melba can chime in. One, you can report it to the internal affairs unit for that particular law enforcement agency. I know there could be a level of distrust there, but also you have my office. Like I said earlier, we have a public corruption unit. So if you feel that you've been unlawfully arrested, you feel that there's been an issue, there's been some level of misconduct that's been exhibited by that law enforcement officer, you can then contact our office, and our public corruption unit can look into it and open a file. But you have avenues. You can contact my office, or you can reach out to that law enforcement agency's internal affairs unit.
And there may also be a civilian investigative panel in Broward County as well as another option to be able to report unlawful arrests or excessive violence or anything like that.
Um, Thank you so much to both of you for being here this evening with us and answering these questions. And I know that we couldn't get to every single question, but if any of you would like more information concerning this conversation that we had this evening, we're going to be dropping several links into the chat box or the comments. And so the first one is actually so that you can sign up with the ACLU of Florida. You can get more information and actually have a one-on-one with me in particular. If you didn't hear in the beginning, I'm the organizer for criminal justice reform here at the ACLU. And so if you're interested in volunteering or having any more information about that, you can use that link to sign up. There's also a link for our September Month of Actions event. And so that we are pretty much celebrating Constitution Day all month long with a series of different events where you can join us for riveting discussion, specifically around the Constitution, as well as Amend, the series that can be found on Netflix as well as on YouTube. And you can, of course, follow the ACLU of Florida on Facebook or Instagram. And if you'd like to learn more about the state attorneys in Florida and how important their role is in our criminal justice reform work, you can visit our website, ACLU Florida Justice FLJusticeVoter.org for more information there as well. So once again, thank you all so much for joining us this evening. Thank you, Melba Pearson. Thank you, State Attorney Pryor. And I look forward to having more of these events in the future.
Yes. Thank you. Thank you for having me.
Thank you.
No problem.
Take care. Have a good night.
Too.